Distinguished members of the Judiciary, members of the Judicial Academy, ladies and gentlemen, I'm very pleased to be here to take part in the inauguration of this splendid project. The topic I've been asked to talk about is a very large one, and I can only talk about a few aspects. But it's important to keep in mind that the process of reform is a continuing one that can never really be accomplished, because there are always new challenges, various factors which I will talk about, and then I also want to talk about some aspects of the process of reform itself and some points of good practices that ought to be observed. The need for reform can come from the recognition that there is, that well-established ways of doing things are actually creating problems. And I give one example of this recently in Malta. They have had, since the 19th century, a process of pre-trial examination of suspects, which involved the hearing of witnesses before a judge, even before the trial. This was designed to prevent people being oppressively prosecuted, but the process has ended up becoming incredibly complex, overlong, and even before cases get to trial, you're beginning to see violations of the right to trial within a reasonable time. And so reform was clearly needed, something which worked when the situation was easier, there were less crimes, cases were less complex, needed to be changed, and that's now been in the process of being replaced by a system of the introduction of an independent prosecution service and the early disclosure of evidence to the defense, with the possibility of the defense being able to challenge the trial, the case even being sent to trial on the basis that the evidence is inadequate. That will bring much greater speed. A second factor leading to the need for reform is the emergence of new challenges for criminal justice systems. This can come from new means of criminal activity, the problems of cybercrime, which we'll hear more about later on, for instance, the dissemination of exploitative images of children on the internet. You need new criminal offences, new means of investigation. These all have to be undertaken, but they need to be done in a manner which is in conformity with the essential requirements of the European Convention. The third situation giving rise to the need for reform is the realization the problem actually exists. This can be seen, for example, in the increasing realization that hate speech is a problem. Hate speech is not something really new, but we are beginning to really take it much more seriously, and action needs to be taken in respect of it. The same is true of the question of domestic violence. Domestic violence has always been with us. The very use of the word domestic was a way of trying to stop people treating it as a matter of the criminal law, saying it's an internal family matter. That now has changed, and in particular the need for action has been reinforced by the adoption of the Istanbul Convention, and various efforts are being made to try and implement it. But the adoption of the Istanbul Convention was actually really, in a way, a codification of much that had already been happening in the development of the case law of the European Court, notably in cases such as Sandra Jankovic against Croatia and Opus against Turkey, where the failure to deal with domestic violence was seen not only as giving rise to violations of the right to life and the prohibition of inhuman treatment, but also a violation of the prohibition of discrimination. So the case law of the European Court shows a light on many issues which need to be addressed, and this has been true in a whole range of European countries. Sometimes people are taken by surprise. When the convention was adopted, people often thought that their systems were perfect and that the convention was merely a reflection of what their legal system provided. But in reality, the convention is a living instrument adapting to new circumstances, and all legal systems in Europe have had to change their legal systems in various ways. You have, for example, in Belgium, there used to be the situation where the Advocate General would take part in proceedings of the Cassation Court, supposedly to help ensure consistency in case law. But the reality was that the court discovered a denial of the equality of arms, because there was the potential for the Advocate General to take part in proceedings when the defendant was not present. You see this also in the discovery through the concept of fairness of various implied elements. So, for example, the privilege against self-incrimination is not written in the Convention, But the court has underlined in a large body of case law that this privilege is something which is integral to the guarantee of the right to a fair trial. And a whole range of circumstances have been developed in terms of where the privilege of self-incrimination might arise, even dealing with, for example, roadside questioning by a police officer when someone makes a statement in a very stressful situation which may ultimately prove prejudicial for their trial. It's also, the question of fairness has also been important for the development of case law relating to the use of entrapment to create criminal offences. Undercover police operations are integral for dealing with many forms of criminality, and the European Court is not against those happening. But the way in which undercover operations take place must be such that what you're doing is discovering real criminality and not actually seeking to create offences which, but for the intervention of the undercover operation, would not exist. You see it also in a very substantial case law which has now developed with various cases, particularly before the Grand Chamber, dealing with the problem which is endemic in many legal systems of situations where witnesses cannot attend court hearings. To what extent can you rely upon the statement of someone who is dead, who has gone abroad, or is seriously ill? These raise questions for the fairness of the trial, and particularly when you cannot examine that situation. And the court has developed various ways to help states deal with situations to ensure that you can use such statements while maintaining fairness in the proceedings. Similarly, the court has been confronted with the new extended use of plea bargaining, where you try to accelerate criminal proceedings by encouraging offenders to plead guilty when it's clear that they have done so, but at the same time, you need to make sure that this is not done in an unfair and oppressive way. And the case law has laid down very important principles directing that. But the reform can be needed not simply to address new developments, it can also be to deal with new problems. And so, for example, we've heard already about the need for respect for Article 8, the right to private life in dealing with the use of surveillance techniques. And at the same time, the case law of the court has identified a whole range of important safeguards which need to be respected. It's also important, as was made clear by Christophe Poirel earlier on, that it's important that when you engage in tackling criminality, that you don't just focus upon rights such as Articles 5 and 6, but you make sure that you don't violate other rights in the course of doing so. And this has been true in a range of offences, particularly freedom of expression, but in many other instances can also be cited. And that's in particular in terms of the way in which the offences are drawn up, because even if you're trying, for example, to tackle hate speech, it's important that you don't actually bring within the range of hate speech things which are legitimate political criticism or the undermining of the legitimate activities of political opposition. And therefore, guidance about how to draft offences is extremely important. Similarly, it's important to ensure that the penalties are not disproportionate. This, in many instances, is where you see legitimate activities in law reform taking place, but unfortunately the way in which the penalties are drawn give the courts no real discretion, and as a result, the penalty imposed in particular cases is disproportionate. There is a need, therefore, for sentencing guidelines so that all relevant factors take place. The reform in Europe has not just been about dealing with many of these things which can be seen as incremental. Particular difficulties arise. In particularly the countries which have joined the Council of Europe in more recent years, there has been a need for very fundamental reform to the justice systems. And so, for example, if you look at a number of countries, notably Ukraine, you've seen the development of a completely new criminal procedure code, which has sought to reflect the requirements of the European Convention in considerable detail. The consequence of this is that you've seen the institution of the investigative judge to ensure that the pre-trial investigation complies with the rights in Articles 5 and 6. And you've also seen, very importantly, the introduction of a free legal aid system which applies to all people who've been deprived of their liberty to ensure that they actually get advice from the beginning of the pre-trial procedure. And this is supported by the development of over 100 free legal aid centres and a special service designed to ensure lawyers can provide that advice even out of normal working hours. Similar reforms are taking place in other similar countries. But you have not only the problem of creating new institutions such as the investigative judge, but you also have to face sometimes the need for reform of existing institutions. For example, if you look at the Republic of Moldova and also Ukraine, there's been a need to reevaluate the way in which the prosecution system has functioned consistently with the requirements of the Convention, so that you have autonomous decision-making by individual prosecutors and protection of the prosecution service itself from outside political influence. This is quite a challenging task to establish a genuinely independent institution, one that is quite complex, and in the case of Ukraine and Moldova has also meant changes to the constitution to ensure that this independence existed. But changing the institution isn't enough in this regard also. You need to make sure that you have other factors which might undermine it. So, for example, the disciplinary system, which was used in Ukraine extensively as a way of imposing the will of senior prosecutors, totally unconnected with legitimate considerations about prosecution, has had to be reformed in order to ensure that disciplinary action was taken for proper reasons and not for improper reasons. And you also have had the needs for sometimes particularly new institutions. Ukraine, again, has had problems with the issue of corruption and abuse of office, particularly by law enforcement officials. And that's led to the creation of two entirely new agencies, one responsible for dealing with the investigation of corruption, and the other, the State Bureau of Investigation, dealing with improprieties by law enforcement officials and other public officials. Now, those institutions are ones which respond to a very particular problem in the context of Ukraine. But I think there will be interesting lessons to be learned from seeing how those institutions that work, how those lessons can be applied in other contexts without necessarily the need to establish new institutions. You also have had considerable work done in terms of looking at the way in which people are trained and prepared for becoming judges and prosecutors. There is a tendency in training to focus on simply people being given lectures, which is not actually a very good and effective way of training people to take on the responsibilities of being judges and prosecutors. And you see in the judicial academies and training centers of some East European countries and as well as some West European countries a move to have training which is based less upon what is learned in the classroom and more through what is done in practice. And so, for example, you have time spent with a prosecutor seeing what's to be done before you actually take on those responsibilities. And also the training of senior prosecutors to act as mentors to junior prosecutors so that their work can be improved. These are all challenging developments. They take time, and reform is certainly not something which you can say has been totally effective. Some of these things are still very much work in progress, but they do show the range of possibilities which exist in a whole range of European countries. Some very fundamental changes, but certainly ones capable of providing lessons. And I think looking at that process of reform within particularly the newer Council of Europe member states, there are a number of issues which are worth bearing in mind. The first is that I think there is a need for a wide involvement in the reform process so that there is both a good understanding of what the reform is trying to achieve and that those who are affected by the reform actually understand the importance of accepting it. If you look at some of the countries at certain points when reform was being attempted, there was really no serious attempt to have this involvement of all involved, as a result of which there was often an unwillingness to embrace the reform. People wanted to keep using the old practices because they were used to doing that. They didn't appreciate the significance of the change, and as a result of which they tended to undermine the legislative changes. They didn't always work at first, and the consequence of that was not only that the reform didn't happen, but it also meant that there was a lack of public confidence because they did not see any real change taking place. So that wide involvement is important. Secondly, and closely connected with that, is the importance of leadership where reforms are being proposed. In some instances, I've seen in situations where those who are the leaders of the prosecution or the heads of the judiciary not really being interested in the reform at all. And that message, which is indicated by both express and implied behavior, has resulted in those who are supposed to be implementing the reform not actually undertaking it, and as a result of which the reform has been delayed in some instances. Thirdly, reform needs always to be accompanied by the necessary resources and infrastructure. It's no good simply saying we've made the legislative change. If, for example, you want to have video recording of what happens in a police station or in a courtroom, it's no good providing a video recorder in a few police stations or in a few courts when actually you need it in all of them. And again, in many instances, there have been occasions where I've seen judges queuing up to use a courtroom because they need to have the video recording, but there is only one video recorder in a particular court building, and therefore that doesn't really work. Similarly, if you change the distribution of functions between people, you've actually got to reallocate the personnel. So, for example, in Ukraine, you have a situation where the prosecution have ceased to do investigation. That role has been given to investigators, but for a long time there was a failure to transfer people who did investigation work in the prosecution to the new investigation service, the consequence of which was that the investigators were actually overworked and the prosecutors underworked. You also need, if you have a legal aid system, to ensure that you have the finance for it and also the infrastructure to provide legal assistance, and that means ensuring that lawyers are actually available. You also need to take account of the fact that reform impacts not simply upon the Criminal Procedure Code, but will affect other matters as well. So as I mentioned about the question of discipline, if you have a question of worrying about how autonomy of prosecutors is protected, then you need to focus upon the disciplinary code and also the ethics code to ensure that this functions effectively. You also need to worry about whether or not there are impacts on other areas of the law. As I mentioned before in relation to penalties, if penalties are too high, then in those circumstances you will have problems. You also, however, need to take account of the fact that when you make one change, it may actually lead to problems which you don't think about. You need to try and anticipate difficulties. In the case of Ukraine, for instance, the creation of the investigative judge was a very good development. But one thing, a very important thing, was forgotten. When they created the investigative judge was responsible for remanding people in custody. But there was no provision for dealing with the situation when the person who was remanded in custody was transferred to the jurisdiction of the trial judge. And yet that person still needed to be remanded in custody, but there was no one with the authority to remand that person. And of course the consequence was the remand in custody was unlawful because there was no legal power, a very straightforward violation of the convention. So you need to make sure that when you make one change, you don't create new problems. Sixthly, you need to make sure you have appropriate time for implementing the change. Some member states have adopted laws which come into effect immediately or do so with very little delay. In some cases that might not be problematic, but in the case of reform to a system of criminal procedure where you have significant changes, then you have real problems. If you rush the reform, you don't engage in all the changes that are needed, and in particular provide appropriate training and guidance as to how the new rules are to operate. And that means, for example, guidelines being developed by the chief prosecutor or by the senior courts, but also producing training material, books, and other analytical work. Training itself is, of course, a real need, and without that, if that training doesn't take place, then reform will be handicapped. Finally, I think the most important lesson to learn is the need to keep monitoring the operation of the system after changes have been made, and to keep an eye on what is happening in the case law of the European Court. When you make a change, you cannot assume that everything will work perfectly. You therefore need to check and see whether difficulties arise and make adjustments. There is no completely perfect reform. There will always be a need for some modification to ensure things work effectively. Similarly, you need to keep an eye on the case law developments of the court. And I think it's particularly important not simply to focus upon the cases from one's own country. Those are very interesting and important. They're directly relevant. But the case law involving other countries is also important, because you should look at that and say, what does this mean for our system? What would happen if this factual situation arose here? Would we have a problem, or are we satisfied? Those are questions you need to ask yourself, because if you don't reflect upon how your system functions, then you may find yourself in the same boat as the member state which has had that case in. So the task of reform is, as I said, both a continuing and demanding one. Rising to its challenges is a price worth paying for a justice system that meets the requirements of a modern age, without at the same time sacrificing the requirements of the European Convention. Thank you very much.